Hello everyone, my name is Captain Virgil Decker. I am the Command Judge Advocate for 85th Troop Command. Today I will be giving you a brief on the Uniformed Services Employment and Reemployment Rights Act, better known as USERRA. Today we're going to cover the background of USERRA, prerequisites for its coverage, what USERRA itself protects, possible employer defenses, and who to contact if you have a USERRA related issue. Today, USERRA applies to virtually every U.S. employer. In general, USERRA protects and preserves three big things. First of all, it prohibits employment discrimination based on past, current, or future military service. Number two, it protects reemployment rights for persons absent from employment because of military service. And number three, it preserves the benefits for persons absent from employment because of their military service. In order to obtain these protections and preservations afforded to service members under USERRA, you must first have either, any type of civilian job. You must be absent due to the military service, not due to something else. You must provide your employer advance notice. Your military service cannot exceed 5 cumulative years. You must be separated under honorable conditions, and you must report back in a timely manner. Civilian job under USERRA is defined as being employed by someone else. It does not apply to people who are self-employed, employed for brief non-recurrent periods, independent contractors, or students. There are, however, USERRA-like protections for students under a different statute, 20 U.S.C. 1091C. Absence due to military service applies if you're called up for Title 10 active duty federal service or Title 32 status in support of a federal mission. USERRA does not cover National Guard duty in a purely state status like 502F, COVID relief. However, there are state laws in place that apply to Connecticut businesses that provide service members with the same USERRA-like protections, the members of the National Guard or reserves. Of course, you must give your employer advance notice. The notice can be either verbal or written, but it should be in writing to protect all parties. There's no time frame specified in USERRA, but regulations recommend at least 30 days prior to you being called up that you give your employer that notice. There are exceptions to the notice requirement. It's based on military necessity or unreasonableness. All this boils down to is give your employer fair notice. Try to give at least 30 days if you get called up for orders. USERRA protections apply for a period up to 5 cumulative years. USERRA protections do not apply if the period exceeds the 5 cumulative years. As I mentioned before, your discharge characterization matters. You must be discharged under honorable conditions. There's no USERRA rights for you if you are separated dishonorable or bad conduct discharge for enlisted, dismissal for officers, under other than honorable conditions, discharge, or for an officer dropped from the rolls. If your discharge is later upgraded, USERRA does apply and the employee has the right to be reinstated, but you are not entitled to receive back pay. You have to report back to your employer in a timely manner. Use common sense in this case. When you return or when you're about to return, give them a heads up you're coming back to work. If, however, you're disabled or impaired due to the military service you just came off of, you have up to 2 years to request reinstatement. The employer must make reasonable accommodations to take you back in, unless doing so results in an undue hardship. USERRA has outstanding protections. It protects you from discrimination due to your military status. It provides for prompt reemployment and training. It guarantees you accrued seniority as if you never left along an ordinary trajectory of promotion and advancement within the company. It maintains your health insurance coverage. It gives you special protection from discharge. Anti-discrimination provision is pretty broad. It says literally a person who is a member of, applies to be a member of, performs, has performed, applies to perform, or has an obligation to perform service in a uniformed service shall not be denied initial employment, reemployment, retention in employment, promotion, or any benefit of employment by an employer on the basis of that membership. Some common benefits of employment that you won't lose: If you get called up on active duty as protected by USERRA, your pension plan and your health plan. A USERRA employee who meets the criteria upon completion of a period of service in the uniformed services shall be promptly reemployed in a position of employment. A little bit more on that promotion. It's called the escalator principle. Increasing an employee's seniority concurrent with military service, meaning an employee returns to the seniority escalator at the same level as if they had remained continuously employed. A person who is reemployed under this chapter is entitled to the seniority and other rights and benefits determined by seniority that the person had on the date of the commencement of the service in the uniformed services, plus the additional seniority and rights and benefits that such person would have attained if the person had remained continuously employed. As I mentioned, soldiers are entitled to prompt reemployment, training for the position, and if they come back with a disability, they get another position which is equivalent or the nearest equivalent in seniority status or pay and reasonable accommodations. Soldiers may maintain their health insurance coverage for up to 2 years or shorter if they come back sooner under USERRA. A soldier who elects to continue coverage must pay the following depending on length of military service. If it's under 31 days, regular employee share premiums. If it serves over 31 days, no more than 102% of the full premium under the plan. Employee share, employer share, and 2% administrative costs. When you get back, there's a grace period for adjustment. You can't be discharged from employment except for cause. Miscellaneous protection, some little known facts. The employee can't be forced to use vacation time to perform military service. The employer, not the employee, is responsible for covering the employee's shift or job, i.e. finding a replacement. And pension benefits. The time performing military service counts toward pension time requirements. The soldier must make contributions if they're part of a plan. Even if a soldier meets all of the prerequisites under USERRA, there are certain employer defenses that will not get that soldier their job back. The 4 big ones: if the employer has a significant change in circumstances, it's an impossibility defense. Can't hire him back, it's just impossible. Undue hardship on the employer, say they significantly downsized, they've completely changed their business, something like that would place an undue hardship on the employer. They don't have to hire the soldier back or the service member back. They don't have to hire the service member back if it was brief or non-recurrent employment, right? But that was more a prerequisite. It has to be a full-time job. The burden of proof is on the employer, meaning the soldier comes back, met all the prerequisites, says, hey, reinstate me in my job. The burden of proof is on the employer to prove one of these affirmative defenses. The following 2 vignettes depict actual USERRA situations. Joe Smith is a simple case. Joe Smith is a patrolman in the state police and a petty officer in the Coast Guard Reserve. He is mobilized and deployed to Southwest Asia as a member of a port security unit. While Smith is on active duty, the state police offer patrolmen like Smith the opportunity to take a test for promotion to sergeant. Missing the opportunity is a big deal because the opportunity arises infrequently. Under USERRA, it states that the state police must give Smith the opportunity to take a makeup exam after he returns to work. If the employee is successful in the makeup exam and, based on the results of that exam, there is a reasonable certainty that he or she would have been promoted or made eligible for the promotion during the time that the employee served in the uniformed service, then the promotion or eligibility for promotion must be made effective as of the date it would have occurred had the employment not been interrupted by uniformed service. The second case is a bit more complex, and I won't get into it fully, but basically what it boils down to is if the employee returning from military service is reemployed in the escalator position that I mentioned before, the employer must compensate him or her at the rate of pay associated with the escalator position. The rate of pay must be determined by taking into account any pay raises, differentials, step increases, merit increases, or periodic increases that the employee would have attained with reasonable certainty had he or she remained continuously employed during the period of service. In addition, when considering whether merit or performance increases would have been attained with reasonable certainty, an employer may examine the returning employee's own work history, his or her history of merit pay increases, and the work and pay history of employees in the same or similar positions. For example, if the employee missed a merit pay increase while performing service but qualified for previous merit pay increases, then the rate of pay should include the merit pay increase that was missed. Your 3 big points of contact for USERRA questions, specific and general, your ESGR, your DOL vets, or your local SJA office. I, serving as the command judge advocate for Troop Command, you can write my phone number down and ask me any USERRA questions, and I may refer you to the appropriate legal assistance office. But my phone number is 860-965-0084, and I'll give it again at the end. Here's your contact information for the ESGR. Here is your contact information for DOL Vets, which stands for Department of Labor, Veterans Employment and Training Service. Who does not use ESGR, Vets, or Attorney General assistance, or is unsuccessful with these entities, they can file a private lawsuit. State employee, file suit in federal court. A private employee, file suit in federal court. Federal employee, special rules apply. Your legal assistance attorney, JAG, like I said, I'm the command judge advocate for 85th Troop Command. I don't do a lot of legal assistance, but I can refer you to the appropriate resources. I'd be glad to answer any general questions or even some specific questions if I have time. Again, my name is Captain Virgil Decker. My phone number is 860-965-0084. Call me if you have any questions. In conclusion, know your USERRA rights and your obligations, your prerequisites. Keep the unit and your employer informed of what's going on. Give them a copy of your orders. Know who to contact if you have USERRA-related problems or issues, especially as it pertains to reemployment, the promotion issues. Where should I start back when I come back from a long tour, whether it's 1 year, 2 years, 3 years, 4 years. It's going to be pretty complex, and you may need a second opinion on where you wound up. So it's been a pleasure. My name is Captain Virgil Decker. Please give me a call if you have any more questions. This is the last slide. Again, my phone number is 860-965-0084. Be well.